Fransi ni wakumakanak ni totemak aqua ni tinimak. There has been a bill introduced at the Senate. Leaders have been actively advocating and lobbying in addressing the second-generation cutoff and ending that discriminatory practice. Solutions to this issue is restoring sovereignty, correcting discrimination on citizenship and membership. Citizenship is an inherent sovereign right. Before the arrival of Canada, before the signing of treaties, First Nations exercised full governance over their own citizenship and belonging. Our nations have always defined who our people are, not colonial registrars. No treaty ever surrendered or transferred this inherent right. In fact, the spirit and intent of the treaties were meant to preserve and protect our governance, not replace it. Indian status is a federal administrative category. It does not define who we are. It does not create our treaty rights, our membership, or our identity. Every nation retains the inherent right to determine its own citizens, according to its own laws, kinship systems, and cultural traditions. The Indian Act interferes with these rights, and its discriminatory rules, including the second-generation cutoff, must be replaced by Indigenous-led citizenship laws. Ultimately, the Indian Act should be abolished and repealed, with nations reclaiming full jurisdiction over citizenship and membership. So what's happening in Canada is as follows. The second-generation cutoff, created through the 1985 amendments to the Indian Act, Bill C-31, prevents many descendants of First Nations people from receiving status after 2 generations of parenting with non-status partners. This rule operates mechanically, ignoring family ties, culture, and Indigenous identity. It has caused decades of harm, disproportionately affecting families of women who lost status under earlier sex-based discrimination. With Bill S-2 now before Parliament, Canada has a historic opportunity to eliminate this rule and respect First Nations' inherent authority over citizenship. Historical context: 1869 to 1970s. Colonial laws imposed patriarchal rules such as marrying out, stripping women of status while granting it to non-Indigenous wives of status men. 1985, Bill C-31, restored status to many but created new categories, 6-1 and 6-2, and introduced the second-generation cutoff, creating a new form of discrimination. 2009 to 2017, court cases, McIver, Deschanel, Gill, confirmed ongoing discrimination. 2011 to 2019, C3 and S3 addressed the double mother rule and the 1951 cutoff. 2021 to 2025, Nicholas vs. Canada and national consultations led to Bill S-2 and renewed pressure to eliminate the cutoff entirely. Impacts on First Nations, cultural and identity loss. Third-generation descendants raised in their nations are legally cut off. Gendered harm. Descendants of women remain disproportionately affected. Family fragmentation. Siblings and cousins may have different status entitlements. Governance challenges. Band membership systems and funding formulas struggle under contradictory federal rules. Violation of sovereignty. The cutoff interferes with nations' inherent authority to determine their own people. Key issues for ministers and chiefs. The cutoff contradicts treaty promises, which never extinguished First Nations' control over membership. The UNDRIP Act commits Canada to ending discriminatory systems and co-developing new legal frameworks. Consultation must focus on how to end the rule, not whether it should end. Recommendations for all nations. 1. Affirm and declare your sovereignty on citizenship and membership. Pimichikamak did this already. 2. Work to eliminate the Indian Act and prepare to transition back to self-governance on citizenship. 3. In the meantime, eliminate the second-generation cutoff, replace 6-1/6-2 distinctions with a non-discriminatory entitlement model that does not extinguish identity after 2 generations. Make a one-parent rule. 4. Restore status retroactively. Provide automatic or application-based restoration for individuals and families previously excluded. 5. Affirm First Nations citizenship authority. Protect nations' rights to define their own citizens, separate from federal registration categories.
Reform or remove double majority voting barriers so nations can maintain control over their lists and governance. Ensure that registration changes do not override indigenous laws of belonging. 6. Resource the transition fund, administrative capacity, healing initiatives, community planning, and demographic impacts. 7. Plan for the Post-Indian Act. Future co-develop pathways for nations to replace Indian Act registration with First Nation citizenship laws, building toward the complete repeal of the Indian Act. Ending the second generation cutoff is more than a legal correction. It is a return to First Nation sovereignty over our people, our nations, and our futures. The federal system must no longer dictate who is or who is not First Nation. Eliminating this discriminatory rule is a necessary step toward restoring identity, honoring treaties, and moving beyond the Indian Act altogether. Under our inherent right of self-determination, the nation will define how treaty citizenship is passed down. A central principle to restore fairness and eliminate Indian Act discrimination is the one-parent rule. Any child with at least one biological or legally recognized parent who is a citizen of the nation shall be recognized as a treaty citizen of the nation with full rights, responsibilities, and entitlements as determined by the nation's laws and customs. This recognition shall not be limited or restricted by federal Indian status categories, blood quantum rules, or any provisions of the Indian Act. This would restore what the Indian Act disrupted, our kinship-based system, where children belong to the nation when their parent belongs to the nation. It ends the discriminatory second-generation cutoff imposed by Ottawa, ensures that future generations remain part of the nation without federal control. Ekosani.